Hi, it's Mike DelSignore, Massachusetts criminal defense lawyer. In today's video, I want to talk about a recent case results I had in Wrentham District Court on an OUI case. My client was arrested by the Walpole Police Department. This was a case that had some difficulties in it, and that's what I want to get into today, is what happens if you have some bad facts. Sometimes clients will come to me, they'll read the report, and they'll be like, geez, there's nothing we can do. We need to resolve this case. Well, don't panic. Relax. Let me look at the case. Let me work on the case. Because I've had a lot of cases where at first glance I thought we had an issue here. But a lot of times when we look at things, take a little deeper breath, take a deeper look at the case, we can find a defense. And we don't need to refute everything. And that's the big mistake people make on these cases, in OUI cases. They think, well, I got to refute every little thing that they say. No, we need to create reasonable doubt. So what that means is we're really just knocking off a chip, a piece of the case. They can keep the rest of the case. We only need reasonable doubt, so we don't have to overprove the case. So this basically, you got three aspects of the case the way I see it. You have the driving, the field sobriety test, and the booking. What you want to do is you want to create some doubt in preferably either the driving or the field test, the roadside encounter. A lot of times we can get doubt in the booking, but that's not as powerful, obviously, because it's later in time, but still, that's an area where you can get reasonable doubt, especially when there's a video, when someone's polite, cooperative, respectful. If we can get a piece of evidence where the jury or the judge sees the person, that in itself can be sort of a trump card. That a good photo, a good video, even if it's only for 2-3 minutes or however long it is, that can be enough to say, geez, that's inconsistent with this picture was painted at the scene of someone impaired. So this case I had in Wrentham, the issue was they had some sort of embarrassing facts. They tried to make my client look like he didn't know what was going on, look like that he must have been impaired. They were trying to suggest he was in an accident. But what I was able to do is, and we met quite a few times, we prepared the case and discussed, and he testified and he explained things away that were in the report. I wasn't going to be able to get the officer to concede or diminish the value of their evidence on cross-examination. Now, in a lot of cases, my ideal case would be my person can sit down, not say a word, and I can create reasonable doubt through the cross-examination of the officer. But sometimes, knowing how they're going to testify, knowing the officers, I know that while it might I might be able to trip up the officer. I might be able to make them look bad on a few points. I know at the end of the day, it might fall short. So if I have somebody that is articulate, that after working with them, I know that I can put them on the stand, I can enhance the case. Because if you're in front of a jury, yeah, they do want to hear from the client. I think it's naive to think that juries don't want to hear the person get up there and say they didn't think they were impaired. I think they do. So if I have, a lot of my clients are very well educated, they have jobs, they have families, and once you put aside the initial fear of testifying and initial thoughts that don't match with reality, a lot of people think we're going to be in a giant courtroom, a lot of people are going to be there, and they get more nervous. And then when you actually see the courtroom, you're like, okay, this is a small courtroom, no one's here. It's not as intimidating as most people think. And once we go over the case, you realize, geez, you're only going to be up there for 5 minutes, maybe 10, and you're going to tell your side of the story. And is that going to be the whole case? No, I'm still going to cross-examine the officers, but it's a piece now that I can say adds to reasonable doubt, because you didn't have to testify, you didn't have a burden. And it brings out the human element. A lot of my clients are very likable people. It allows the jury or the judge to know what you do for work, get a better idea of your family background, how you spend your day. They kind of can picture you as a person, and that can be helpful. So in this case, I think that was the key to the success in the case. If you have a hard case, you might need more evidence. You might need a witness that was with your client. You might need medical records, a video. You need something, but and in this case, it was the person testifying. So keep that in mind. Just because you read the report, you think, oh, geez, this is a strong report. That's not the end of it. We can add to the narrative of what the jury or the judge is going to hear by bringing in other evidence. We're not bound by what they say happened. The report is their version. We can bring our version. We can show that this isn't quite the way it happened. So if you have an OUI case, feel free to call me. My name is Mike DelSignore. I do a lot of work out of Wrentham District Court. I handle cases all over Massachusetts. Be happy to help you. Call, text anytime, 781-686-5924.